Ms Diaz.
Commissioner, the next witness is Ms Riches. She's in the witness box.
Ms Riches, do you mind standing a moment? Can I ask whether you would prefer to make an oath or take an affirmation?
Affirmation, please.
Affirm the witness, please.
I solemnly and sincerely
I solemnly and sincerely
declare and affirm
declare and affirm
that the evidence I shall give
that the evidence I shall give
will be the truth,
will be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you very much. Do sit down. Yes, Ms Diaz.
Your name is Suzanne Riches.
Yes, that's correct.
Ms Riches, you've provided your home address to the Commission.
Yes.
Ms Riches, did you receive a summons to attend and give evidence before the
Yes,
Commission
I
today?
did.
Do you have a copy of the summons with you?
Yes.
I tender the summons, Commissioner.
Exhibit 3.29 will be the summons to Ms Riches. Yes.
Did you make a statement to the Commission, Ms Riches, dated 18 May
Yes, I did.
2018? When you prepared your statement, did you have regard to emails and documents that you sent or received that you'd retained?
Yes, I retained them on my personal computer.
Did you refresh your memory about dates and other details by looking at those documents when you
Yes,
prepared
that's
your
correct.
statement?
That's correct, yes.
Now, Ms Riches, can I ask you to turn to the bottom of page 3 of that statement, and specifically paragraph 16. Are there any changes you would like to make to that paragraph?
Yes, paragraph 16 should read that I submitted a formal offer from Sue Rich to the vendor for $275,000, not the $280,000, $100,000 that was.
Do you have a pen there, Ms Riches?
Yes.
Can you please make that change and initial it?
Yes.
And with that correction, Ms Riches, is your statement true and correct?
Yes.
I tender the statement.
Exhibit 3.30, the statement of Ms Riches of 18 May. Yes.
Ms Riches, what is your occupation?
My occupation is a primary school teacher.
How long have you been teaching for, Ms Riches?
42 years.
In your statement, you refer to a decision to buy a franchise. When did you start looking into that?
It was early in 2012, around April, end of March, April. My husband had received an inheritance from his mother's estate and wanted to secure his financial future and was looking at purchasing a business.
And can you tell the Commission about the franchise opportunities that you looked at around this time?
We looked at a couple of franchise opportunities, a Subway in the southern suburbs of Adelaide at a very small shopping centre complex, 2 Wendy's outlets at the Westfield Marion Shopping Centre, and another Wendy's outlet in the Maya City Centre.
And which franchise did you decide to buy, Ms Riches?
We decided to go for the 2 Wendy's outlets at Westfield Marion.
And were you given any documents at this time about those outlets?
Yes, from the sales consultancy we received a business profile of the 2 Wendy's outlets at Westfield.
And can you recall anything from the documents or the outlets themselves that made you want to buy those outlets?
Once we received the business profile, we passed it over to our accountant to do the due diligence on the figures and to let us know if it was a viable proposition or not.
And did you intend to work in the business yourself, Ms Riches?
No, I did not. I intended to keep working so that my wages would cover the current house mortgage and our living expenses for the family.
Do you recall becoming aware of the lease terms of the outlets?
We noted the lease terms in the business outline profile, yes.
And do you remember what they were?
The outlet downstairs was due to expire in September 2013, and the kiosk outlet upstairs in January of 2015.
And can you explain to the Commission a bit about the leases, or who had the head lease and then what the sublease was? Can you explain a bit about that?
Yes. The Wendy's Super Sunday organisation held the head lease with the Westfield organisation, and as franchisees we sublet from the Wendy's.
Now, Ms Riches, did you need a loan to purchase the business?
Yes, we did need a loan.
And did you approach any banks about getting a loan?
Yes, we first approached the bank that my husband banked with, the Commonwealth at Westfield Marion, and spoke to their business loans officer, and handed the necessary paperwork at a short meeting.
And what did the bank say to you, the Commonwealth Bank, about the loan?
Excuse me. A couple of days later, we contacted the bank again and went down there, and she indicated that they were unable to service a loan for us based on the information we'd supplied them.
Was there any other reason given, or?
She did mention the short nature of the leases as a factor.
Now, you describe in your statement approaching the Bank of Queensland after that.
Yes.
And you went to a branch in Adelaide.
Yes.
Which branch was that?
That was the Perry Street branch.
I see. Now, you describe in your statement about speaking with the branch manager there. There is a non-publication direction, Ms Riches, in relation to the name of that branch manager. Yes. So I won't refer to his name. I'll call him the branch manager.
Me too.
And can you do the same? Thank you.
Me too.
Thank you. So is that the person you spoke to when you first went to the branch?
Yes, we spoke with the branch manager.
And do you remember what you discussed when you first met the branch manager?
We discussed that we were very interested in purchasing the 2 Wendy's outlets at Westfield, and through our son, an acquaintance of our son who worked for the Bank of Queensland, that the Bank of Queensland were looking for customers and they might view our application favourably.
Did you discuss at this point how you would repay the loan with the branch manager?
No, it was basically to ascertain what the documentation that was perhaps required. And I guess we did mention that because the house and the block of land at Normanville was in my name only, that it would have to be a loan taken out with myself as the sole director or applicant.
When you refer to sole director, which was the entity that you're referring to that you would be director of?
We were going to set up through our accountant a business, Sue Rich Proprietary Limited, ATF, the Riches Family Trust.
And you referred to securities before, a house and
Yes.
the Normanville lot. Can you
Yes,
tell
we
the
had a
Commission
block of land in the Lynx Lady Bay golf precinct at Normanville, and the family home at Hallett Cove.
And did you discuss the security in that first meeting? Or?
Yes, we did.
Okay. And did you provide the branch manager with any documents at that time?
I don't believe it was at that meeting. It might have been at the next meeting, which was very shortly afterwards.
And do you remember what documents at that next meeting you provided to the branch manager?
I provided the deeds for the block of land and our house, taxation returns, PAY, bank account statements with the credit union. I believe all the necessary documentation that they needed to ascertain my financial status.
And was any information about the outlets provided at that time?
I can't be certain whether we had the at that meeting whether we did have the business profile at that stage, but I know that it was very shortly delivered to the bank and to the accountant on the same day.
And you mentioned the accountant. Is that your accountant?
That's my accountant, yes.
And you discussed with him the business profile?
Yes, yes.
And what
He
did
made
he
a
say?
copy of it.
Okay, and what did he say about that?
He made a copy of it, and he wanted to review the figures that had been supplied by the vendor, and he was going to perform the due diligence on those figures for us.
Okay. Now, in June of that year, so approximately a few weeks later, did you get some further advice about the purchase from your accountant or your lawyer about the outlets?
Yes, the accountant wanted to also seek some advice from a noted lawyer in Adelaide, so passed on the business profile to their firm to preview, and we received via the accountant notes after his perusal of the document.
Now, you don't exhibit this to your statement, Ms Riches, but it is an email that you received. I'll pull it up. It's fos.0012.0001.1249. Have you seen this before, Ms Riches?
Yes.
And I know you can't see this, it's been redacted, but you have been copied in to this email. It was your email address in the CC
Yes.
field. Now, there's some handwriting on here. Is that, whose handwriting is that?
That's my handwriting, my notes.
When did you put that handwriting on that email, Ms Riches?
I put that handwriting on the email before I forwarded it to you as part of the evidence that I had.
So this email, you didn't put the handwriting on this email during the FOS process?
No.
Okay. And the highlighting, is that
I'm sorry?
the highlighting? Is that your highlighting?
My highlighting, no.
No. Okay. Now, you can see in that email that the lawyer is saying, before committing to purchase, the Riches need to find out or confirm that new 5-year terms are agreed for both the franchises and the leases from current expiry dates, and what costs will be involved in the renewal. In particular, it will be important to find out what Westfield will raise the rent to and whether a refurb of the stores will be required on renewal. I'll just pause there. So with the lease terms, did you conduct any further inquiries around this?
We did through the Wendy's legal department. They indicated that it wouldn't be appropriate, seeing as we weren't the new owners of the business, to seek 5-year extensions, putting the current vendor in a situation.
Do you mean by that because the current vendor has the legal relationship at that point?
Yes.
I see. And then in the bottom paragraph, the email says, the bottom line profits already look skinny to me, especially if deemed salaries for proprietors working in the business have not been included in the salaries expense figures. I think large rent increases or large capital cost on refurbs would hurt these businesses. What did you think when you read that comment?
We were advised by our accountant that there was a small margin in the businesses. However, in discussions with the Wendy's franchise manager and other franchisees that we visited in the Wendy's franchise in other shopping centres, we were aware that Wendy's had a training program and protocols and strategies in place to be able to improve the profits by 10%, and they were tried and true strategies that had worked for the company before. With my husband's expertise in the hospitality industry as a chef and a caterer, he was very confident that he had the means to be able to improve the percentages.
Ms Riches, you made an application to the Bank of Queensland.
What
for
are we
the-
doing with the email, Ms Diaz? Are we
Oh, sorry.
tendering it or what?
Apologise, Your Honour. Commissioner, attend to that.
Exhibit 3.31 email between Riches and Vlasis, 15 June 2012, FOS 0012 0001 1249, exhibit 3.31.
Thank you, Commissioner. Ms Riches, you applied for the business loan at the Bank of
Yes.
Queensland, is that correct?
Yes.
And what loan amount did you apply for at that time?
280,000, I think, is on the loan application.
Now, before you made an offer to purchase the business, you had a discussion with the branch manager about whether you could make the offer without it
Yes.
being subject to finance. Can you tell the Commissioner about the discussion that you had?
I was made aware that there was another possible person interested in one or both of the Wendy's sites, and so I was anxious to find out whether we would be granted a loan by the Bank of Queensland. So my son accompanied me and my husband, and we made an appointment with the manager. And after going through some discussion, I specifically asked him, given the information you've been supplied with and your calculations, are we in a position to be viewed favourably for this loan? And I remember asking 2 or 3 times and specifically saying, I'm going to ask you a question. Will the Bank of Queensland be able to supply a loan for us? To which he answered yes.
And then you made an offer to the bank.
On the basis of that, I then asked again, so I can make an offer to on the 2 Wendy's outlets that isn't subject to financial approval. He said yes.
And did you make an offer?
Yes, I did.
And then you later signed a contract of sale?
Yes.
Your offer was accepted?
Yes.
Now, did you provide a copy of the contract to the bank after that?
Yes, the day I supplied the contract, I signed the contract of sale, I went straight to the Bank of Queensland and our accountant, and they both made copies of the document.
Do you remember approximately the date that you did that?
It would be around the 4th of July because I took a day off school to do that.
Now, do you remember receiving a conditional letter of offer from the bank?
Yes, I received one in August.
And you've exhibited that to your statement at tab 7. That's BOQ.001.0023.1417. And you see there, Ms Riches, the term is 84 months and the repayments are $4,420 per month.
Yes.
Or the indicative monthly repayment amount. Did you discuss these figures with your accountant?
I passed or forwarded this on to our accountant so that he had those figures to enable him to determine the affordability, but and he said that it fitted into his figures, his calculations.
Okay. And after that, you did some training at Wendy's?
Yes. We commenced 4 weeks of training with the Wendy's organisation.
And you refer in your statement to a cooling off period in respect of the purchase, the contract.
Yes.
When did you find out about that?
We knew that before we started the training with Wendy's. We knew that we had to do 3 weeks in stores working and 1 week of administration at their head office, at the conclusion of which there was a 14-day cooling off period on the franchise agreement.
And do you remember signing the franchise agreement with Wendy's and when that was?
Yes, we were given the franchise agreement in the 2nd week of our training, and we were asked to initial the pages to save time. And then when I'm not clear, but I'm pretty sure the franchise agreement was forwarded to us by mail once the cooling off period had elapsed.
And when do you think you provided a copy of that to the bank?
I know I was very expedient with all of the documents that I had to supply to the bank. It would have been after the 5th of October.
Now, the settlement date under the contract was varied. Do you remember what it was originally and what it was varied to approximately?
It was around the 5th of October or the 6th of October originally, and I did sign an amendment. No, it was earlier than that, and I did sign an amendment to be around the 8th of October. Sorry.
Do you remember having discussions with the branch manager about what was causing the hold-up with the loan finalisation and the delays to the settlement?
Was this after the settlement date? Are you referring to after the settlement date had elapsed?
No, well, prior to that. Did you have any discussions prior to that, leading up to the 8th of October?
Prior to that, on the 3rd of October, we visited the bank to speak to the manager to ascertain when we should pay the deposit money and the monies that we had to put towards the settlement, the final settlement figure, and to which account they would have to be put into.
And did the branch manager tell you about what was happening with the loan at that time and getting final approval? It
was sort of at this point that he said there was a difficulty. I think I can remember him saying that perhaps the person who organised or oversaw the credit facility was away and he was awaiting him to come back.
And as you got closer to the settlement date of 8th October, did you make inquiries with the branch manager then as to what was happening?
Yes, I would have made a number of phone calls, and I know I did send a number of emails reminding him of the settlement date and that the money needed to be in the conveyancer's account at that time.
And could you meet that settlement date of 8 October? Did the settlement take place on 8th October?
No, the settlement did not take place on the 8th of October.
And do you know why that happened? Why there was that delay?
I guess the final loan application hadn't been processed.
So after that, did you have any further discussions with the branch manager about trying to get the settlement?
Yes, many phone calls and emails, and I was assured that they hadn't exhausted all the possibilities.
What was the branch manager referring to in that regard, possibilities?
I don't know. I'm not sure, but it sounded as though they were trying to find out a way to be able to service the loan.
And did he talk about what the credit department was doing? Or what might have been holding things up?
No. Oh, he did mention the nature of the leases, the short term of the leases, and I was surprised at that because that would have been in the business profile that was supplied to the bank much earlier before the loan application.
Now, on 15 October 2012, you received the final letter of offer, and that's at tab 12 of your statement, BOQ.0001.0023.0014.
That's correct, yeah.
Did you go to the branch to receive this? Is that where you received it?
Yes, I was telephoned and told that the loan documentation was ready to be signed.
Now, at this stage, you hadn't met the settlement date.
Correct.
Had you had communications with the vendor about that?
Yes, the vendor's conveyancer sent, I believe it's a notice of default, and I was being charged interest for every day that we were late in settlement.
Now, if we just pan forward a couple of pages in that final document, see if I can find it. You see on the next page, .0001115, the facility amount is $280,000, but the repayments are now $8,696.89 per month.
Yes, that's correct.
And the term of the loan is 3 years.
That's correct.
Were you given an opportunity to read all the documents in the branch at that time when you went in that day?
Yes, I was given the folder, and I read through the pages and came to that final letter of offer and noted that the amount and the term for the repayment was different.
Did you mention that to the branch manager?
I did mention it to the branch manager. I was alarmed that the amount had almost doubled from the $4,400, and that the term of repayment was only 3 years.
What did he say?
He said that was due to the nature of the leases. That was the only way that they could get the loan through.
Did he say anything else about?
He did mention that there could be a review after a year of the interest rates and the repayment term.
Now, you went ahead and signed that offer and accepted that offer, Ms Riches, is that right?
Unfortunately, yes.
Why did you do that?
I felt I was in between a rock and a hard place. The cooling off period had elapsed on the 5th of October. I had no way to get out of the contract. There was threats of legal implications. I sort of felt I was in a no-win situation.
Now, after you took over the business, how did you travel with making your repayments?
It was very difficult because the delayed settlement date meant that we missed out on a very lucrative 2 weeks of school holidays. The Marion Shopping Centre is overloaded and crowded with school children and people. On the basis of the figures from the previous year, we missed out on $40,000 worth of revenue, which made it very difficult when we were buying stock and also to furnish the rent that was required for the next month. We only had a week to try to get the money together, whereas had we gone in at the beginning of October, we would have had 3 weeks trading plus those 2 lucrative weeks of the school holidays.
And how did you travel in 2013? Were you able to make your repayments then on the interest?
I tried to make payments where possible, when possible. I don't have the bank statements with me that verify actually how much I was able to put in, but it was very, very difficult to make those repayments.
And you mentioned that you had the Normanville lot. Did you end up having to sell that?
Yes, that was after some time when the Bank of Queensland sent a notice of default on payments, that we spoke with our accountant. Or the notice came through the accountant's office as our registered office, and we had a meeting and discussed that perhaps the way forward was to sell that Normanville lot.
And did you continue operating the 2 outlets in the Marion Shopping Centre?
We did until the lease on the downstairs shop ran out. Under advice from our accountant and looking at the figures compared to the figures that we were supplied with from the previous vendor, we decided that it was losing money and that it was probably better to let the lease go and concentrate on the kiosk upstairs, which was a larger and a busier outlet.
And how long did you keep operating the kiosk for?
We kept operating the kiosk until mid-2015.
In July 2014, you commenced a complaint in FOS.
Yes, I did. That was after we tried through a financial agent to refinance the business loan.
And did you also make a complaint to the bank about?
I did in the early stages, not long after we had started the business, because I wasn't at all happy with the way that we were dealt with, and I felt I was concerned at the delay and the loss of revenue. Those, I think, paramount was the, in my mind, was the loss of money from those school holidays, and that we were behind the eight ball, so to speak, trying to play catch up all the time with our finances. Regrettably, I didn't include in that letter about the surprise at being presented with the loan document folder that the term was reduced to 3 years and the repayments were double.
And during the FOS process, you received documents from FOS, including some of the documents that the bank had
Yes.
provided to FOS.
Yes.
And did you note anything about the documents that you received?
We noted on their calculations of that some items had been omitted and crossed out.
What are you referring to, Ms.
On
Riches,
their
from
calculations of perhaps our ability to service the loan, that there were things crossed out that we didn't feel it was right for them to cross out without perhaps contacting our accountant or us.
And crossed out from where, Ms. Riches?
From the figures of the previous vendor
I see.
that they would have used.
And FOS ultimately found that the bank hadn't delayed the settlement, but had misled you about the monthly repayments, but you would have not exercised the cooling off period. What did you think about that when you read that?
My husband and I didn't feel that was up to them to decide on that.
Who do you mean by them?
FOS to decide that we wouldn't have cooled off. We referred all our financial dealings to our accountant, and had we known the increased payments and the short term, we would have referred that to him straight away, and we would have been able to go through the training period knowing that at the end of it that it was not financially viable to repay $9,000-ish a month, and we would have reneged on the franchise agreement.
Did you discuss with your accountant what his advice would have been if he'd got those figures?
After the, we did after. He indicated that he would not have let us go ahead with it had he had those figures.
Initially, you wrote back to FOS about the recommendations and expressed your disagreement, which is
Yes.
just
Yes.
outlined. And then subsequently, the company was placed into liquidation. Is that right?
That's correct. Yeah.
And FOS made a determination. Did you accept that determination?
I guess the determination was more in our favour than the first determination, and we felt as though it was the best that we were going to get.
But ultimately, was it the liquidators that accepted the determination?
Yes, I did get a phone call to say that I wasn't, because the business was in liquidation, that I wasn't in a position to accept it. So the liquidators rang for my advice, and they accepted it on my behalf.
And after that, what happened with your loans? What did you do about them? Did you receive more demands?
In accordance with the requirements of FOS, I sent two letters to the Bank of Queensland in the school holidays to let them know my financial position, and a proposal for some sort of repayment.
And what's the status of the loans right now? Ms Riches?
The loans I've been able to refinance through the ANZ Bank.
When did you do that?
We did that, I think it was 2016. In around about March.
Okay. Now, Ms Riches, I want to ask
I
you
think
about...
yeah.
You want to check that date? Do
Yeah,
you want to check
I
the
just
statement?
do.
Yeah.
I would like to check that date.
Yes.
Yes.
Could have been the following year.
Oh, sorry. 2017, I'm sorry, I apologise.
Yes. Okay. Now, I wanted to take you to some letters that you received this year. Now, you exhibit a few of these to your statement. One is at tab 24, BOQ.001.0030.1955. That's dated 22 March 2018. Do you remember receiving this?
Yes, I do.
Now, what did you understand this to be in relation to?
I was quite bemused at receiving it because as far as I was concerned, we had met all the requirements in the deed of forbearance, paying out the business loan and remortgaging the house. So I believed that there was a nil balance owed.
Okay. And then the next letter that you received, SGR 25, that's tab 25 of the folder in front of you, Ms Riches, BOQ.0001.0032.0001. So this letter says we refer to our letter dated 22 March 2018, the letter we just saw. Our letter was sent in error. We withdraw the letter and confirm that no amount is owed by you to us. Now, did you have any other communications with the bank at this time?
No, not then, but I did receive an SMS friendly reminder on my phone to say that the account was in arrears, so I contacted the bank straight away.
You telephoned the bank and spoke to
telephoned the
someone?
bank, yeah.
And what did they say?
And the person I spoke to had said that he was aware of the letter that was sent, and he was sending another letter confirming that there was a nil balance there.
And is
There
that
was
before
no
you
debt.
received this 16 April letter?
No, that was after.
After. Okay. Well, we'll go to the next letter. That's at tab 26, RCD.0024.0009.0001. So this letter says urgent reminder, 17 April 2018. This is the next day after, or date of the next day.
Yeah.
And this says your account is overdrawn or in arrears. And it's essentially in the same terms as the 22 March letter. So you received this,
Yeah.
did you?
Yes, I did.
And what did you take to be
I think
happening
this
this
is
time?
after the 17th of April. I think it was perhaps the 19th of April that that I got the text message and I made that phone call to the Bank of Queensland.
I see.
I think it was 2 days later.
Okay. And then you received another letter, and this is at tab 27, RCD.0024.0009.0002. This is on the 19th. This is dated the 19th of April.
Yes.
Do you remember what date you might have received this? Was this received around that same time, before the text
I
message?
think it was. I think it was received a few days later, after the 19th.
Okay.
Yeah.
And was it before or after the phone call that you had?
No, I can't be certain on that. I'm sorry.
Okay. And this letter says our letter was sent in error. It refers to the 22 March letter. We withdraw the letter and confirm that no amount is owed by you to us. Now, Ms Riches, have you received any other correspondence since this time?
Yes, last Friday,
Is that Friday the 18th of
Friday
May?
the 18th of May, I received an urgent parcel to be delivered before 9 a.m. and to pay a cheque or any more money because they had to calculate the amount owing, and there was a $10,000 amount, $10,969 amount that was added to that deed of forbearance.
But you didn't hear about it until, you didn't hear anything further about that until Friday?
No. No, we paid the $10,000 so that we could clear the account, and I didn't hear any more about this until I spoke with Brendan Kennedy when he rang me to assure me that there was a nil balance, there was not $7,000 owing, and I asked him to check on this statement that I keep getting, the investment account that had this credit amount in it.
And have you banked the cheque yet?
Yes, I did bank the cheque.
Okay. Thank you, Ms Riches. No further questions.
Yes, Mr Hartley.
I don't know if Your Honour is proposing to...
How long do you expect to be, Mr Hartley?
Your Honour, I'm sorry, Commissioner.
Those days have gone,
It's
Mr Hartley.
a habit, sorry, and I will stop it. I want to ask one or two questions because something arose in the course of the witness's evidence which has been the subject of discussion between ourselves and those instructing counsel assisting about the availability of Mrs Riches' documents, which we don't understand were delivered to the Commission, yet she appears to have referred to them for the purposes of a statement. And as I understood, the matter would usually stop at this hour. I'm in your hands completely, of course, Commissioner.
Stop it anywhere between 4 o'clock and 4:45, I'm afraid,
Oh,
Mr Hartley.
I was told it was 4:45.
We should be so lucky.
I'm a new boy. That's what I was going to say, because I understood the hour, is that Mrs Riches seems to have had access and refreshed her memory by reference to documents which are not in the possession of the Royal Commission, and therefore I thought it was appropriate that I get access to that material before I ask her any questions. I had not particularly intended to ask her questions for the reason we hadn't had access to the totality of material, and I thought it was quite frankly inappropriate to be cross-examining witnesses in a matter such as this until if I hadn't had proper access to all that was before her. Therefore, we're in a bit of a catch-22, or as we perceive it. What I was going to propose to you, Commissioner, is that if Mrs Riches could produce to the Commission this evening all the emails, because there must have been quite a lot for reasons which I don't want to belabour you with, which we haven't seen, such that we could see them overnight, and then I would be in a position to indicate what, if any, cross-examination I wish to develop. I don't want, it's not an inquiry, of course, into Mrs. Riches,
Right.
It's an inquiry into the bank, and it was only purely if they went to matters concerning the conduct of the bank that I proposed to ask any questions. And as currently, they would be of a very limited compass, if at all. That's to be completely frank with you, Commissioner.
Mrs. Riches, you've come over from South Australia, true?
Yes, I have.
That's the difficulty I'm facing.
May have access to her email accounts. That's the which we of course she's referred to, particularly referring to emails, and it seemed the correspondence on the whole took place, so far as we can infer, by email, Commissioner, and I was hoping that might be a means of getting access to the back material, but I'm completely in the Commission's hands, of course, in that regard.
I don't want to cut you off, Mr. Hutley, from something that you think needs to be investigated in the interests of the bank, but it may be better, Mrs. Riches, if you'd be good enough to leave the hearing room for the moment and just wait outside. If you wouldn't mind just taking a seat outside the hearing room, Mrs. Riches. Thank you. And the chief focus of her evidence seems to be on what she would say was a change in the arrangement between one conversation and a final letter of offer.
It actually went through 3 evolutions.
Yeah.
You've only heard of 2, I think. There was a further letter which hasn't been brought out in her evidence, but that's in effect a repetition of another letter.
And then there is a series of steps she refers to that as occurring, in effect, post-liquidation and post closure of the business. Now,
I accept that. I think there is a confusion in the witness which is becoming all too apparent about what's called a cooling off period. I think, in fact, there was one Wendy's cooling off period,
yes,
and there was a statutory cooling off period, which is a different cooling off period. And that's a cooling off period, I think, as a matter of law, which only arose when the agreement with Wendy's was consummated. And I think that, on the evidence, was only on the 6th of October. And one of the things that is apparent, and that I'm inferring from the evidence and what I've seen and her evidence about when the agreement was entered into, which makes, I think, perfect sense now, that raises the issue that her opportunity, in effect, to get out of this contract as a matter of law appears to have commenced on the 6th, not ended on it.
be it so. Let's assume for the purposes of debate
Fifth
that
or
that's
sixth,
right, and
yes.
I have no view about that one way or t'other yet.
Quite.
What then follows about what I should end up writing in a report about conduct that is either might be misconduct or conduct falling short
I understand.
concerning your client?
I understand completely, and that's why we didn't propose to go into these matters for that. But the FOSS attributed a proportion of responsibility. And I don't know at the end of the day, for example, whether you, Commissioner, will be considering, in effect, particularly in a small business field where one has people who are anxious to go forward and who are often have deep belief that they are able to achieve things which perhaps their advisors might have told them is really unachievable. And that's the commercial reality, and in effect, that's the wonder of entrepreneurial enthusiasm.
Yeah.
And what does become perhaps of some little importance, perhaps, is that if Mrs. Riches and her husband were in contact with their lawyers and accountants from the 6th or 5th or 6th of October onwards, what they were saying, what they were thinking, and for example, Mrs. Riches says in her statement, there were delays in the settlement. And with the benefit of hindsight, if she knew, in effect, she had the opportunity to get out at the time, if she had the opportunity, she may well have got out at that time. Now, she may have been, and she appears to be, and we don't suggest she's anything other in this regard, and I'm not because I'm in contradistinction to else, other than being honest, she may well have been being inadequately advised by her lawyers, her accountants, and Wendy's about...
Be it so. Assume all of that were to turn out in that way. What then would follow about what I should or shouldn't write in a report?
Your Honour, sorry again. Commissioner, you may well view in this particular area the position of banks cannot become akin to that of a custodian of the interests of the small business holder, because they need to and should be looking to their own advice, because on the whole they have the intelligence and sophistication to, in effect, protect their own interests. And whilst the banks may well have many policies to protect their interests, and obviously the banks can't engage in anything which is sharp practice, misleading conduct or the like, but you are being asked, as I understand, to in effect consider the position of the banks being put in some overarching or in effect almost custodial position, quo-ad certain classes of their clients.
And what I'm being asked to consider in this, at least as far as I can see from the way the evidence has come out, that the bank, through its manager, says one thing at day one, it changes, whether it's day 2 or day 3, whether it's offer 2 or offer 3, at some later point, bank manager says, there's the final offer, it's different from.
I accept that. In point of fact, what you say, Commissioner, is completely... Your role, as I understand it, will not solely be to deal with the case studies.
Ah.
You'll have to look at a much broader questions as to how banking should be, on one view, conducted going forward. The detail of your case studies, and as said, particularly in this field, the human character of the engagement, the types of, as it were, advisory positions which are to be expected to be involved, may be something that bears upon your evaluation as to where, if it is to occur, some balance is to be set. I put it no higher than that, and that would be the only reason we would investigate it if we considered it appropriate tomorrow. That's the sole matter, because I accept that the overwhelming thrust of your undertaking is, of course, to look at what we did, as it were. I put it no higher than that, Commissioner.
Now, whatever this is, it ain't adversarial litigation.
Precisely. That's why we come not here, and I'm quite frank, we do not come to have determined what might be a legal outcome between ourselves and Mrs. Riches. We are not interested in that, and the bank is not being adversarial. We merely raise this issue to expose...
Nor are you entitled to have discovery of her documents.
We're only entitled to have that which you tell us we're entitled to have.
Well, that's putting it crudely but bluntly and accurately.
And I accept that absolutely, but I merely raised it because of the hour. Yeah. And counsel assisting may be able to find out whether the emails can be produced overnight by a short questioning of Mrs. Riches.
Why should you have access to her emails? Why should you have access to her emails? In the sense that if they're emails to and from your client, you've got them. If they're emails to somebody else, why should you have them?
Commissioner, often emails to third parties.
I've got to do natural justice to your client.
No, I understand it. I understand it. I'm not
I need to know why I would not be doing natural justice if I said, no, you can't have what she's gone to someone else.
Often in the communications to third parties that one finds out the detail of one's dealings with both the bank and one's own thought processes.
Yeah.
That's the reason why, as you would have in your experience.
Things I haven't seen, they're things I can't use to form my views. Why should you have them?
Because, and solely this, matters may be being advanced critical of my client in relation to these transactions, and legitimately, I say, may well be, and anything which reasonably should be, that might, as it were, ameliorate the possibility that my client is not being, as it were, exposed. The true milieu would be a matter which you, Commissioner, might think was fairly put before us. If it can be conveniently done without interfering the proper flow of the Commission, and I put it no higher.
Well, what do counsel assisting want to say? Mr. Hodge?
Commissioner, could I deal with this, although ultimately Ms Diaz may or may not need to ask some more questions? It's unclear what exactly it is that Bank of Queensland wants and what Mr Hutley is seeking, and frankly, if it's now going to be suggested that the Commission needs to issue notices to produce to other customers of Bank of Queensland in order to bring in documents so that they can then be disclosed over to Bank of Queensland so it can then consider some process that it's going to adopt, we're going to need much more specificity about what it is.
And at the moment, I should issue a notice to produce requiring Ms Riches, because I can't, I'm not going to ask her to do anything. If I'm going to, anything is to be done, it's going to be done compulsorily, because unless I do it compulsorily, she is not, does not have the benefit of the protection. So what I'm being asked to do is either to issue my summons or issue a notice to produce for her the content of her email account as to communications with her lawyers, her accountants. Don't know whether they go beyond that in relation to this transaction.
And so, as thus far, as best I've been able to follow it, there have been at least 3 possible lines that have been suggested that Bank of Queensland might like to pursue. The first line, which I understand it is something that apparently was already apparent to them on the basis of Ms Riches' statement, which is that they thought that there were things on her statement that indicate that she must have had reference to some documents, and presumably they could identify now what those things are. The second thing is that there was then the shadow raised of the possibility that the advice that Ms Riches had received from either her solicitors or from her accountants was in some fashion negligent or problematic, and it has to be assumed that therefore the purpose of that would be to seek to get access to any emails that have been exchanged between Ms Riches and her accountants and solicitors. About that, can I say 2 things? First, of what possible relevance could that be to the conduct of this inquiry? How does that help in any way, given that it's not raised at all, whether on, as it is, as to the conduct of the bank, to consider whether or not there is some negligence on the part of the solicitors or accountants acting on behalf of Ms Riches if, as has already been said, there's no challenge to the belief of Ms Riches as to the fact that there was no cooling off, there was no further cooling off period that she could exercise. And the second point is, this presumably is not a matter of accounting advice, it's a matter of legal advice, and that's going to be covered by privilege anyway, which means, Commissioner, that even if you were to issue a notice, the consequence is if there was hypothetically legal advice and it's not been suggested that there is any, it wouldn't be something that could be produced in any event. And then the third thing that seemed to be raised at the end was the idea that there needed to be some inquiry into Ms. Riches' thought processes. And presumably the implication of this is that the Bank of Queensland would like to try to seek access to some other documents that they think exist that might reveal something that Ms. Riches has said to some other person at a contemporaneous time that is in some fashion relevant to what her thought processes were. And with respect, it's just very difficult to see why it is that any of that needs to be pursued, but much of this can be bedded down. If there are already documents that Bank of Queensland has identified that they think are missing, they can tell us now what they are. And if we have them and they are relevant and they are within the Commission's records, then presumably they can be provided to Bank of Queensland. And if they think they exist but they're not sure, then Ms. Riches can be brought back to the stand and asked about those particular documents. As I understood it, the question that she was asked at the very outset, which was, have you had reference to some other documents, was a reference to, she's got very specific dates in her statement. And I had assumed, perhaps wrongly, that that was a reference to the types of emails that would record meeting, that is, a meeting is to occur on a particular date. But I may have misunderstood, and it may be that there are other documents that Mr. Hutley is trying to raise. But all of this just requires some greater level of specificity.
Yes. Mr. Hutley?
As I said at the outset, Ms. Riches said fairly and frankly she's had regard to her emails and records for the purposes of giving evidence today. Now, I don't know what the full panoply of those are. It's a Rumsfeldian known unknown in that regard. And therefore I'm unable, as my learned friend would know, to particularise what I don't know. Now, it's just the fairness or otherwise which arises out of that circumstance which I am directing, seeking the Commission's indulgence in relation to the production of the materials to which she's had reference.
Do you accept that I could act only by a compulsive process and should act only by way of compulsive process?
If you, I accept that, Commissioner. You feel that that's the appropriate course, and I would not suggest for a moment to the contrary.
It's only things produced in response to compulsive process that attract the privileges prescribed by the Act.
I accept that.
Commissioner, I'm sorry, could I just be heard about one matter? Because I think there's just been a qualification to the position of Bank of Queensland. If the only thing that Bank of Queensland is interested in is understanding what the documents were that Ms. Riches had reference to in the preparation of her statement, then presumably we can just bring her back in, she can say what they are, and then Mr. Hutley can indicate what his position is.
Like one of those examination
Well,
objections where there's a debate for 3 hours and then the witness is asked the question and the witness says, I don't remember.
but the difficulty is this is now a totally different track from this idea of we're going to investigate what legal and financial advice she was provided.
Let's cut through this. Let's have Mrs. Riches back. Somebody go out and get up. Mrs. Riches, in your line of work, sending somebody out of the room is usually seen as a particularly nasty thing to do.
At least
it was not intended in that fashion.
I don't have a dunce's hat on, so that's all right.
So, Mrs. Riches, you were asked a question at the start of, or early on in your evidence, whether you had looked at or taken into account any other records that you may have access to in giving the evidence that you have given today. Do you remember being asked a question about that?
Yes.
To what documents or records did you have regard when preparing to give your evidence today?
I had emails between the bank manager and myself and our accountant and the conveyancer, which helped me ascertain which month and which date certain things occurred.
Yes. And you say that those matters helped you identify which month events occurred. Was there any other material in that material you examined that assisted you in your recollection of events as you have described it in evidence today?
I guess the sequence of events and the nature of what the meetings were about.
Yes. In light of that, Mr. Hutley, why should I issue any further compulsive process?
I'll say nothing further.
Yes. Do you wish to cross-examine Mrs. Riches?
No.
Thank you. Yes. Then thank you, Mrs. Riches, for your attendance. You may step down. You're excused further attendance.
Commissioner, there was one further correspondence or document that wasn't tendered, which I should do as a matter of housekeeping.
Yes.
That was BOQ.0001.0093.0112, the letter that was received on Friday, 18 May, by Ms. Riches from the bank.
And is that the same as RCD 002400090003, which is the last of the documents?
No, Commissioner, this is not an exhibit. This has to be tendered.
There's another one.
Yes, that's right.
So how do I describe it?
Letter received by Ms. Riches.
Letter from BOQ to
Suzanne
Riches, dated.
Friday. Oh, it is not dated, but received on Friday, 18 May 2018.
Will become exhibit 3.32. That's BOQ 00100930112.
Thank you, Commissioner.
Now, Mr. Hodge, where do we go from here? Not tonight. We're going nowhere tonight except out.
Commissioner, the next witness will be Mr. Snell from the Bank of Queensland.
Yes.
So we'll start him.
Start with him at 9:45 tomorrow?
Yes, and we may make a slight adjustment tomorrow afternoon, just depending on, we have a consumer witness, so we'll just switch case studies around depending on.
But 9:45 tomorrow, and expect to begin with Mr. Snell.
Thank you.
Very well.